Ryan?
Good afternoon, everybody. This program is being recorded for those of us who weren't able to start live. My name is Felix Yellen. I'm the Chancellor of the Louis D. Brandeis Law Society. We're happy to have you here, hopefully in the future or now, to discuss a very topical and important issue, which is the requirements for COVID-19 vaccination and how it intersects with employment law. Right now, I'm going to turn it over. First of all, before I do that, thank you to White and Williams for hosting this and for working with us on this. I'm going to turn it over to Vice Chancellor Natalie Clish-Thorney, who will introduce Tanya Salgado, the other panelist, and start the program. Thank you.
Thank you, Felix. Tanya, thank you so much for joining us for this very important program. Tanya Salgado is counsel at White and Williams, where her practice includes employment law, education law, and commercial litigation. For more than 20 years, she has defended businesses and nonprofits in federal and state courts in cases involving allegations of discrimination on the basis of age, race, national origin, disability, and sex discrimination, as well as claims alleging sexual harassment, FMLA, and wage and hour violations and wrongful discharge. Thank you, Tanya.
Thanks for having me.
So why don't we start discussing this very important topic about vaccines in the workplace. We're going to discuss the various employment aspects of vaccine programs and understanding your environment, as well as what policies make sense and how to successfully increase vaccination levels. My understanding is that there have been requirements previously of flu vaccination, specifically in the healthcare realm. What can we learn from these flu vaccination policies?
Sure, I think that's a really good starting point for discussing mandatory vaccinations for COVID. Prior to this global pandemic, mandatory vaccination policies were relatively rare. The only employment settings in which you would typically see a mandatory vaccination policy would typically be a healthcare setting, hospitals, perhaps nursing homes, or other settings where you have direct care of medically vulnerable populations. And so in the past, we really didn't have necessarily a robust area of case law dealing with vaccines, but we can learn from claims that have arisen from these mandatory vaccination policies in the healthcare setting. So typically how these claims would arise, a healthcare employer would institute a mandatory vaccination policy requiring all of their staff to get a flu vaccine. And employees who objected to the vaccination would bring a lawsuit. These claims typically were based on claims of wrongful discharge, or more commonly, claims brought under Title VII for religious discrimination, or claims brought under the Americans with Disabilities Act. Again, these are claims that are being brought by individuals who have refused vaccination for a variety of reasons. Now, both Title VII, specifically the religious discrimination component of Title VII, and the Americans with Disabilities Act have what's called a reasonable accommodation requirement. That means that individuals who are covered in a protected category under these laws are entitled to request a reasonable accommodation from their employer. And that's where the objections to vaccination typically arise. The legal standard for reasonable accommodation under Title VII and the ADA are similar, but they're not identical. At the end of the day, these issues are fact sensitive, and the types of accommodations will depend on the nature of the work environment.
Tanya, what exactly is protected under Title VII as far as religious beliefs?
Sure, that's a really good question. Now, as I said, Title VII makes it unlawful for an employer to discriminate against an individual because of a sincerely held religious belief. So, that raises the question, what is protected under Title VII? The civil courts have had some reluctance over the years to define religion. And I think that this really kind of goes back to the First Amendment. Civil courts, some civil courts feel they're not really in a position to judge whether or not an individual is correctly adhering to their religious faith based on the separation of church and state. So for that reason, civil courts have tended to take a somewhat broad view of what is the definition of religion. That said, we do need to have some parameters. A leading definition of the term religion comes from the Third Circuit Court of Appeals, and that was in the case of Africa versus Pennsylvania. The Third Circuit held that a religion addresses fundamental and ultimate questions having to do with deep and imponderable matters. A religion is comprehensive in nature. It consists of a belief system as opposed to an isolated teaching. Third, a religion can often be recognized by the presence of certain external and formal signs. It's also helpful to look to the EEOC guidelines. The EEOC has recently updated its explanation of religion in its compliance manual. And one of the items that the EEOC stresses is that a religion may include moral beliefs as to what is right and wrong, which are not necessarily based on a belief in God. An individual can have a belief that's religious, even if there is no formal church that espouses these beliefs, and even if the person's religious group does not accept the beliefs. So based on the EEOC's position, the term religion is really quite broad. That said, there are some limits.
Right, what would not be protected as a religion under Title VII?
So beliefs that are based on social, political, or economic philosophies or personal preferences would not be considered protected. For example, in the case of Fallon versus Mercy Catholic Medical Center, again, another case coming out of the Third Circuit, the employee was a hospital employee who objected to his employer's mandatory flu vaccine policy. The employer asked him to state the basis for his objection, and he said that he refused to be vaccinated because he had a personal belief that one should not harm their own body, and the flu vaccine may do more harm than good. The Third Circuit Court of Appeals held that this was not a religious belief and found in favor of the employer. A similar result was reached in a case out of California. In that case, the employer had a mandatory flu vaccine, and the flu vaccine had a egg component. One of the employees objected to the vaccination because they practiced vegan, they were vegan, and they claimed that this qualified as a religion. Under California law, the court held that this was not a religious creed because it reflects secular rather than a religious philosophy.
Following up on this, what if an employer doubts the request for an accommodation based on religious belief? What can it do in response to that?
Yeah, I think that that's a question that really is best addressed by dealing with a policy. Employers who have decided to institute a mandatory vaccination policy should have a well-defined policy that provides for exceptions for religious beliefs. And in the event that an employee has an objection to vaccination based on a religious belief, the employer is not required to simply accept that at face value. The employer is entitled to ask follow-up questions and make a limited inquiry into the facts and circumstances of the employee's stated need for an accommodation. However, the employer should have an objective basis for making this request. Now, it's important to keep in mind that, when you're seeking clarification, the managers, the employees who were responsible for reviewing the request should be trained in Title VII and have some familiarity with the fact that just because a religious belief seems a little unusual or perhaps even strange, that in and of itself isn't a reason to deny the request. The appropriate way to handle such a request would be to request further information. This could come in the form of a personal statement by the employee as to the nature of their beliefs, or it could, quite often, it comes in the form of a third-party verification. If this is a religion that has clergy, it would be appropriate to request some sort of a note from the employee's church, local clergy, or in the event that this is a religious belief that does not include clergy members, another third-party verification from an individual who knows the employee well would be appropriate. One caveat here, it's important to be careful to avoid excess when requesting this information, because this could lead to claims that the employee is being subject to harassment or perhaps even retaliation.
What are some of the other best practices on religious accommodation?
So again, I think it's important to train your managers in how to spot these types of accommodation requests. An employee may not articulate it so clearly. They may say, listen, I can't get vaccinated because it's a personal belief. That may trigger some follow-up. I think it's important to have an internal policy and procedure so that employees who need an accommodation have clear direction on how to make that request. Again, it's important to assess each request on its own merits, and managers should avoid assumptions and stereotypes. And another thing to keep in mind whenever we're talking about employment law is to remember that when an employee makes a request for an accommodation, whether it be religion or disability, this request is considered legally protected activity. So that if an employee makes a request for an accommodation and is disciplined thereafter, the employee may argue that that discipline was retaliation. So it's important that any employee discipline that takes place after an request for an accommodation be well documented and based on objective violations of company policy in order to help minimize the potential for a retaliation claim.
Jumping to the Americans with Disabilities Act. My understanding is that it requires a reasonable accommodation of a qualified individual with an actual or perceived disability, unless it's an undue hardship.
Yes, that's right. And, in the context of mandatory vaccination policies, there are some individuals, for example, some individuals have severe allergies. Some people have underlying medical conditions that make it unsafe for them to be vaccinated for the COVID-19 vaccine. And in that case, an employer that wants to institute a mandatory vaccination policy needs to have a policy and procedure in place so that individuals who are unable to be vaccinated due to a medical issue have the opportunity to request an accommodation. Now, you had mentioned undue hardship. Some employers may say, it's necessary for employees in this context to get the vaccine. Perhaps it's a healthcare center, a healthcare organization, and the individual is responsible for having direct care of individuals who are medically vulnerable. In that case, the employer would need to look to whether or not it would be an undue hardship on the operation of the business to provide an accommodation. Now, the undue hardship is a somewhat difficult standard to meet. It requires significant difficulty or expense. And so that's why it's very important to carefully consider reasonable accommodations and whether or not that accommodation would truly constitute an undue hardship under the law.
The ADA prohibits medical examinations and questions about disability-related issues. Would the administration of vaccine be considered a medical exam?
So the ADA has very strict limits about questions that employers can ask of employees that are medically related. And the basic guideline is, under the Americans with Disabilities Act, employers are not permitted to conduct a medical examination. They're not even allowed to ask disability-related questions of employees unless the employer can show that this exam or this inquiry is both job-related and consistent with business necessity. So now some employers, particularly in the healthcare setting, have chosen to administer vaccinations to their staff, to their workforce themselves. And that has raised the question, is administering a vaccine a medical exam? And the good news is that the EEOC addressed this issue early on, as soon as the vaccines rollout began. The EEOC explained that the vaccination itself isn't a medical exam, but the questions that are related to administering the vaccine are considered disability related. So for example, when you go in to get your vaccine, there's a list of questions that are asked. If you get the vaccine on your own at the local pharmacy, your pharmacist will ask you that list of questions. When an employer is administering the vaccine themselves, they are the ones, they or their agent are asking these questions. Therefore, that is considered a disability-related inquiry, and the employer needs to be able to show that this is job-related and consistent with business necessity. So for that reason, I think many employers are choosing to, even if they're requiring it as a mandate, they're having the employees get the exams within the community, either going to their own pharmacy or going to their own medical provider to get the vaccine.
What about asking employees to provide proof of vaccination? Would that be considered a disability-related inquiry under the EDA?
So, a lot of employees seem quite concerned about employers asking them for proof of vaccination. The fact of the matter is, and the EEOC has come down very clearly on this, just asking an employee whether or not they've been vaccinated is not in and of itself a prohibited disability inquiry. And the reason for that is because there may be a whole host of reasons why or why not a person hasn't been vaccinated. So just asking an employee, have you been vaccinated? No problem. Any employer is permitted to ask that question. The follow-up question is where employers can get into trouble. And what I mean by that is asking, why didn't you get vaccinated? Because that could very well lead an employee to explain, well, I didn't get the vaccine because I have this underlying medical condition and I'm not able to get vaccinated. So for that reason, if an employer chooses to ask employees whether or not they've been vaccinated, that's fine, but that should be very clearly stated as a yes or no question. I've heard of some employers who are choosing to ask that question and they're actually putting it in a form, yes or no, have you been vaccinated? And then the next question would be, well, what if we want to require proof? Can we ask someone to show their card? And again, the answer to that is yes. The EEOC has made that very clear. Employers are allowed to ask for proof. You can ask the employee to present their card, their CDC issued card, and you can even keep a copy of that card. However, once you obtain a copy of that card, once you ask that question, that information should be kept confidential. The Americans with Disabilities Act does require employers to protect the confidentiality of any type of employee medical information, and that includes vaccination records.
How should an employer respond to a person who cannot be vaccinated due to disability?
So again, employers should have a policy in place that states that any employee who wishes to be exempt from the mandatory vaccination policy due to religion or to disability, there should be a process and a procedure and a policy for how to make that request. So, this question is going to be necessarily specific to the workplace. So the EEOC has provided materials on how to address situations where an employee cannot be vaccinated due to a disability. And it all comes down to what's known as the direct threat analysis. A direct threat is when an individual poses a significant risk of substantial harm to the health or safety of others that cannot be eliminated or reduced by a reasonable accommodation. So when we're considering accommodations, you're going to want to look at the actual risk of harm in this particular setting. So in a healthcare setting, you're going to necessarily have a higher level of risk than perhaps in an office setting where the majority of the workforce has already been vaccinated. So this is necessarily going to be a case-by-case assessment that's going to have to be individualized. The EEOC has recently updated their technical assistance in this regard and provided some practical advice as to what a reasonable accommodation might look like. Depending on the workplace, it may be as simple as requiring the unvaccinated person to wear a face mask. It could involve social distancing, in other words, making sure that their workstation is located at least 6 feet from other employees. It could potentially involve working modified shifts. Telework, if that is appropriate for the job and if it's something that the employee finds acceptable, is also an option. Periodic testing for COVID may be an option, or potentially even reassignment. But again, you're going to want to take a close look at the actual level of risk in the workplace and not base these decisions on unfounded assumptions or stereotypes, keeping in mind that it's important not to treat a person who cannot be vaccinated due to a disability in a way that would be considered adverse.
If an employer decides to exclude the employee from the workplace or reassign that employee to a different location based on inability to be vaccinated, what are some of the ramifications that you see happening potentially?
Yeah, I think that's something that employers do need to take a close look at. I think that if someone is excluded from the workplace against their will, that could potentially lead to a discrimination claim. Now, many employees who have a disability and cannot be vaccinated would welcome the opportunity for telework. And in my own practice, I can say that many employees would be very content to telework. But employers shouldn't assume that that's the case. It may be that for example, in a customer facing position where in order to get ahead at the workplace, an employee does need to be in the office. If they are told you cannot come into the office, you have to work remotely, and that's not the accommodation the employee was looking for, that could be an issue. The reasonable accommodation component under the ADA does require what's known as an interactive process, and that involves communication. It involves give and take between the employer and the employee as to what form the accommodation will take. So I think it's important, again, to keep in mind that the accommodation for an unvaccinated employee should take into account the realistic assessment of the risk rather than just assuming that the employee will pose a threat to others.
Sure, and there's a difference between somebody who chooses remote work and somebody who was basically instructed to do remote work, potentially against that person's will.
Yes.
What about how should an employer deal with other employees who do not wish to work alongside an unvaccinated coworker?
Yeah, this is something I have been hearing quite a bit about, and employers are kind of struggling with working through these morale issues, particularly as workplaces are opening up and as the masking requirements are being rolled back. There's an assumption if someone shows up in the workplace wearing a mask, that must mean they're unvaccinated. And, employees are, we've all been through a lot this past year. There's a lot of fear, there's a lot of concern, and, employees are concerned about breakthrough infections. I think that the best thing that employers can do is to review the data. I think that it's important, if someone comes forward to HR and says, I don't want to work with an unvaccinated employee, you can talk to the employee, you can review their concerns. It may be that you can work something out where, you're keeping them 6 feet from each other. It may be that some employers are requiring unvaccinated employees to wear a mask in the workplace. But the important thing is not to single people out. And I think that workplace gossip should be avoided. And I think that employers can send a message that employees should respect each other's privacy. There may be different reasons why a person is vaccinated or unvaccinated. Some people who are fully vaxxed may choose to wear a mask, perhaps because, they may have a whole host of personal reasons, some of which may be disability related. So I think that it is appropriate for employers to send a message that they should respect each other's privacy. If someone has a good faith safety concern, they should bring that confidentially to HR to discuss, rather than spreading gossip and rumors about coworkers.
If a fully vaccinated employee asks for an accommodation to work remotely because of various, concerns about working with either unvaccinated employees or employees that are now wearing masks, how should an employer deal with that?
Yeah, that's a specific issue that the EOC has included in its updated technical assistance. And it is something that I'm hearing about. And I think that there's sort of an assumption that employers have that, once a person is fully vaxxed, they shouldn't worry. But the reality is there are some individuals who have an underlying medical condition, people who are immunocompromised. Even though they're fully vaxxed, they're still very much at risk. So I think that employers, again, the important thing to keep in mind is to avoid assumptions, avoid stereotypes. It's important to engage in that interactive process, have the dialogue with the employee, And, it is appropriate to request some confirmation from a physician if that's what you need, because it may very well be that the physician is in a good position to give you some information as to what an accommodation might look like. And it may be that the person does in fact need telework. It may be that the person needs to wear a mask. It may be the case that the person needs to work in a socially distanced environment to address this.
One more related issue that we have touched upon is mental health issues under the ADA. The ADA also protects mental illness and mental health disability as well. What if an employee does not want to be vaccinated based on anxiety issues or fear of needles?
This is something that, as I was researching these issues related to flu vaccines, I came across a number of cases in which individuals objected to vaccination due to some sort of anxiety-related issues, including fear of needles, phobias, things of that nature. So I think it's important for employers to keep in mind that mental illnesses can also be a concern that an individual may have, and that this should be part of the interactive process when considering reasonable accommodations. I also wanted to mention, and I know that this is a Pennsylvania CLE, but I thought it was helpful that New Jersey came out with a vaccine guidance for employers. And this was issued right around the time when the vaccine started to become widely available and employers were looking to reopen the workplace. And they even kind of got ahead of the EEOC in that they were giving specific information about how employers should be analyzing the reasonable accommodation. I think there was sort of this initial thought, well, okay, employers are permitted to have mandatory vaccination policies. So if you don't get vaccinated, that's that. But the reality is employers do need to be looking at reasonable accommodations. And what's nice about this particular guidance is that it gets into the specifics, talks about remote work, it talks about PPE, it talks about social distancing in the workplace, finding ways to reduce the risk of harm. And it also talks about the fact that safety is a legitimate consideration, but decisions need to be based on objective evidence rather than on sort of a knee-jerk reaction. And this guidance also addresses pregnancy and breastfeeding, which I think is something that, pregnancy in and of itself is not a disability. Pregnancy is not necessarily a reason not to be vaccinated. It's an individual's choice. There's not a lot of data. Some pregnant women are choosing to be vaccinated, others are choosing not to be vaccinated. And the New Jersey Department of Labor, as well as recent guidance from the EEOC, has explained that employers who have an employee in the workplace who cannot be vaccinated or is choosing not to be vaccinated due to pregnancy or breastfeeding should be considered for accommodation on the same basis as other accommodations, such as for disabilities and for religion.
What about pregnancy in general? Pregnancy in and of itself is not a disability, but many state and local laws require pregnancy accommodations.
That's right. Certainly, again, I know this is a Pennsylvania CLE, but New Jersey as a state has amended their disability or their discrimination law to include and require accommodations. Philadelphia requires pregnancy accommodations, and it's generally being considered a best practice. And I would certainly counsel any employer who is working with an employee who cannot be vaccinated due to, or is choosing not to be vaccinated due to pregnancy, to go ahead and consider that an adjustment to keep working exactly on the same basis as other employees.
I actually read an article last night which had indicated that once the vaccines receive full authorization, not just temporary authorization from the FDA, employers will have an easier time mandating vaccines. Would you agree with that?
Yeah, was that in the New York Times? Did you see the New York Times article?
It was either, yeah, it was either New York Times or Wall Street Journal. I can't remember which one it was.
I just read an article in the New York Times this morning about emergency use authorization, and the point of view that this writer took was that they were encouraging the FDA to just go ahead and get it authorized. So by way of background, the EUA, or emergency use authorization, is a status issued by the FDA in situations such as we're in a public health emergency, in order to get a medication out and available to the public before the full review has been finalized. All of the vaccines that are currently available in the US are available under the EUA status. And this has raised concerns because under EUA status, there's a patient data sheet that states that it's the individual's choice whether or not to receive the vaccine. If you decide not to receive the vaccine, it will not change your standard of health care. So, many people feel as though, is it really appropriate to, or legal to, mandate a vaccine when even the FDA has a statement on the vaccine saying it's your choice? I think in particular, healthcare employers are finding this troubling, whether or not it's illegal to mandate the vaccine despite the EUA status is an open question. I don't think that the legal arguments are very strong to say that it's illegal. I suppose that an argument based on public policy could be made, but even there, it seems to be an uphill battle. Nevertheless, I think that many employers will feel more comfortable mandating the vaccine once the vaccines get full approval from the FDA.
And that'll be good news for us all. What if mandatory vaccination policies, which a number of employers have already taken? For instance, one of our Philadelphia's bigger employers, or probably the biggest employer, the University of Pennsylvania Health System and University. What if a mandatory vaccination policy is challenged? How can an employer best position itself?
So I think the best thing to do at the outset is to, before an employer institutes the mandatory vaccination policy, would be to do a good thorough analysis as to why it's needed. So for example, a large healthcare employer such as University of Pennsylvania Health System, they're going to look at the public health. They're going to look at the individuals who they treat. They're going to look at the fact that it's very difficult to have effective PPE in that kind of healthcare setting, and therefore it's necessary to have a mandatory policy. So they're going to want to have their medical reasoning for why it's necessary in place. Another best practice would be to ensure that their policy requires or provides for exceptions as required under Title VII and the Americans with Disabilities Act, and have a well-trained HR staff as well as managers and supervisors who understand what to do if an accommodation is required. The policy should include reasonable accommodations that are realistic. The reasonable accommodation process should certainly be individualized and look at each situation on its own merits. And, I think that a lot of employers were heartened to hear about the case that came out of Texas. There was a lawsuit filed against Houston Methodist Hospital. That hospital had mandated the vaccine, and a group of employees challenged the policy. And they had several bases for the challenge. They argued that the mandatory policy violates public policy. And they also specifically argued that the EUA status meant that the employees were basically being subject to unlawful medical experimentation. The employer filed a motion to dismiss, which the court granted. The court did not think highly of the arguments either under public policy or based on the EUA status. And one of my colleagues wrote an excellent article. David Edwards wrote an excellent article on this piece that's available if anyone is curious. But I think that case has been encouraging for those employers who are considering mandating a policy.
What about if an employer decides to offer an incentive program? What is a safe way to create an incentive program for employees to incentivize employees to take the vaccine?
So as soon as the vaccines became available, we started hearing news reports of employers who were giving bonuses, gift cards, extra time off to employees to get vaccinated. And I think that employers, outside the healthcare setting, most employers are very reluctant to make policy mandatory, but the thought was, let's choose the carrot rather than the stick and encourage people with incentives. And this seemed to be gaining popularity, but then there were some concerns raised as to whether or not doing so would be considered potentially coercive or even discriminatory. The EEOC has taken a certain position on employer wellness programs and the types of incentives that employers can use in the context of wellness programs. So that kind of put things on a halt. Recently, just within the past couple months, the EEOC has updated its technical assistance and specifically addressed incentive programs. The EEOC has taken the position that if the employer is administering the vaccinations by the employer or by its own agent, that in that instance, the employer has to limit the incentives such that they're not coercive. And the rationale behind this is that, again, when an employer is administering a vaccine, there are a number of questions that have to be asked about the employee's medical status, and these are considered disability-related inquiries, and therefore the EEOC takes the position that the incentives need to be modest and not so large as to be coercive. On the flip side, if the employer wants to offer incentives to employees who get vaccinated by their own providers within the community, their own pharmacist, there's no limit on the incentives that the employer may offer. So I do think this is good news. I know a lot of employers were going ahead and providing these incentives regardless. And it is good to hear that the EEOC has come down in favor of this. I think that we all want to see a higher percentage of the population vaccinated. And if this helps, that's great. Some employers are giving extra time off to employees to get the vaccine. That's certainly a very pragmatic approach, particularly because an employee typically does need a day off after getting the vaccine just because of feeling tired and so forth. Some states have even written laws requiring that employers provide an extra day off to get the vaccine, which I think makes a lot of sense.
Well, this has been certainly very informative on a topic that's very relevant and constantly evolving, and I'm sure will be evolving as we head into the fall and also into next year. Thank you so much, Tanya, for joining us and for lending us your time.
Absolutely. Thank you very much for having me.
Thank you.